Today, I'm doing a presentation over mediation and impartial due process hearings. Mediation is an impartial system that allows the proper parties who have a dispute to confidentially discuss the disputed issues with a neutral third party with the goal of resolving the disputes in a binding written agreement. When it comes to requirements for mediation procedures, the procedure shall ensure that the mediation process is voluntary on that part of the parties, is not used to deny or delay a parent's right to a due process hearing or to deny any other's rights afforded under this part, and is conducted by a qualified and impartial mediator who is trained in effective mediation technique. Some parents choose to take their dispute straight to a due process hearing. Possible reasons are the knowledge that they have the right to refuse, the cost of the process in terms of time, money, and emotional stress, or the anger felt towards the school personnel resulting in the parents wanting a stronger arena. If the parents elect to not use mediation, neither the state nor local school district may deny or delay their right to a due process hearing as a result of this refusal. The mediation process starts with pre-mediation caucuses. Pre-mediation caucuses, prior to the actual mediation, the mediator may meet with the parties individually. These private sessions are called caucuses and may help the mediator and the parties clarify the concerns or provide the parties if they are hesitant with a non-threatening area to first describe their issues of concern. Phase 1. Opening Statements. During this segment, each participant is provided with an opportunity to describe the controversial issues. Phase 2. Agenda Setting. The participants then discuss the issues and decide as a group the order in which the issues and proposed resolutions are to be reviewed. 3. Resolution Option Generation. This is the brainstorming phase of the mediation and judging, selecting, or choosing specific options at this early phase in the mediation may hamper the final ability of the parties to reach an agreement. Phase 4. Agreement Negotiation. During this phase, the mediator may use a variety of methods to facilitate agreement on one or more options for resolution of the issue. Phase 5. Written Agreement Preparation. Usually, it is essential for the negotiated agreement to be finalized in a written format. The mediator can draft this agreement at the end of the meeting and provide the parties with a final document at a later date, or the document can be developed while the parties wait with copies provided to them immediately. After a parent has filed a complaint and requests for a due process, the local education agency is required to have a meeting with the parents and the members of the IEP team knowledgeable of the complaint's facts. The meeting must take place prior of the due process hearing and 15 days within the receipt of the complaint. The LEA's attorney may not attend unless the parent's attorney is there. The purpose is to provide the parents the opportunity to discuss their complaint along with relevant facts that led to the complaint, and to provide the LEA with the opportunity to resolve the complaint before the due process hearing. The resolution session may be waived if both parties agree to do so or if a decision to use mediation occurs. If a resolution has not been made within 30 days of filing a complaint, then there will be a due process hearing. Due process hearing is an official forum that must be conducted by the SCA or the public agency directly responsible for the education of the child as determined under state statute, state regulation, or a written policy of the SCA. It allows an impartial third party known as the due process hearing officer to hear both sides of a dispute, examine the issues presented, and prepare a decision that is binding on both parties. A due process hearing may occur when issues arise related to the initiation and change of refusal of a school to initiate or change the identification, evaluation, or educational placement of a child in special education. The hearing process. The first event is an introduction by the hearing officer. A clarification of the general purpose for due process hearings, and an explanation of the specific purpose of the hearing in question are provided at this time. When the preliminary items have been covered, the hearing officer asks for opening statement. It should include a summary of the issues, the legal basis for the request for due process, and a broad overview of the facts leading up to the case. After the opening statements, the evidence in the form of witnesses is presented. The witness states aloud his or her name and usually his or her title for the record. At this time, the witness may identify documents that will be introduced as evidence. When all the witnesses have been heard, then the school's attorney makes a closing statement. A closing statement should clearly summarize the case for the hearing officer. The final step is the hearing. The hearing officer provides for the record a discussion of when written briefs must be submitted and when the decision will be finalized. After, a hearing report will be completed by the hearing officer. The report will then be given to each party involved and to the State Department of Education.